And we're back, and Kristi Dosh joins us. Tremendous reputation in this space. She is an attorney, a writer. She's also a correspondent for Forbes, has her own website, and is an adjunct professor at the University of Florida. Kristi, first of all, thank you for joining us. What a time in your field. Good afternoon.
Thanks for having me. Yeah, it's a busy and interesting time.
We're delighted to have you, and I know this has been hashed out considerably in the last 6 days, but I'm really curious to put into perspective the ruling from East Tennessee, what it means right now to that particular case, and really what it means in the intermediate and long term to the NCAA's ability to enforce its rules, especially NIL.
You know, that case really, it only applies to the Eastern District of Tennessee, but generally the NCAA has treated any of these sorts of cases as applying nationwide. And so we don't expect them to really enforce any NIL rules. Not that there's been a lot of enforcement action anyway up to this point, but we expect that they're not going to enforce anything specifically against collectives and boosters talking to recruits, talking to players that are in the transfer portal. They're going to be able to make them monetary offers, and those student athletes are going to be able to talk about it publicly. That was already happening, but we weren't hearing about it publicly. And I think actually it's going to offer the student athletes some protections, because if they get a promise or a contract from a school before they commit, and then that isn't carried through on the other end, you know, before they couldn't really talk about it because they were doing something that was against the rules, but now they can call out that collective or that booster. So it may actually give some more protection to student athletes going forward.
Kristi, if you're John Duncan, who runs the enforcement division of the NCAA, and you're a part of that organization, there's still plenty that you can enforce. But on this particular case, I mean, what do you do if somebody calls up with allegations about NIL violations?
I think I save those in a folder on my desktop and say I'll come back to them later because I really don't think there's much they can do right now. So their resources and time are probably better spent on other types of cases before them.
Which I realize there was a lot under their purview, but beyond eligibility questions, which they certainly have a big impact on, just I mean, do you think they still have any bite when it comes to just general enforcement? That it's hard to imagine much going beyond NIL right now, but I guess there's still things that they could legislate, although it doesn't seem likely they're doing much of anything.
Yeah, you maybe have some of these cases regarding talking to student athletes outside of official communication periods and the way that you're communicating. It would be nitpicky little stuff. The big stuff was always involving, you know, activities that were happening prior to NIL in terms of financial offers or cars, you know, those sorts of things being offered to student athletes before NIL went into effect. So ever since NIL came along, you know, it really took a lot of those things off the table, and they've been trying to wrap their arms around, okay, which NIL things are we going to go after and what sort of proof do we need? And we saw last year where they made the rule change. You know, we're used to in the criminal system, you're you're innocent until proven guilty. And they sort of swapped it last year and said, no, we're going to put a new rule into effect that if we see a report in the media, we can treat it as true, and you have to prove that it didn't happen. And that was such a absurd standard. And I don't think now we're ever even going to see that used, because there's really nothing on the NIL side that they can go after right now.
Chatting with Kristi Dosh, who certainly excels in this particular field of trying to interpret where things are legally. Kristi, let me get beyond the Tennessee case, because that is narrow, even though it has great ramifications. But there are so many other important cases. What's next, and how would you describe the next year or two for the NCAA in the courtroom?
It's a lot to keep track of. In fact, I actually sat down and I had a spreadsheet of all the different cases that I'm keeping my eye on, and I ended up publishing a story over on Business of College Sports today, just breaking down, here's all the cases you should be watching. Here's where they're at in the process, because you've got the House case, which has now been certified as a class action. That's a potential $4 billion case for the NCAA, and that relates to student athletes who didn't get to monetize their NIL because their eligibility was up before NIL, or they only got NIL for a year or two. That case is going to be huge and would, break the NCAA irretrievably. Like, maybe you can argue now they still exist for a reason, and they still have a little bit of a leg to stand on, and maybe they can, pursue some sort of federal bill or get some sort of bailout here. But if the House case doesn't go their way, I think it obliterates the NCAA. So most folks I know are watching that one closely. The Johnson case, which is about whether or not student athletes are employees, that one's interesting because it's a little different than like the Dartmouth decision we had recently from the NLRB. The NLRB only governs private universities, but that Johnson case could end up applying to public institutions as well. So when I'm on campuses consulting or speaking and I'm talking to athletic directors about what they're getting ready for, it's the employment issue and whether or not they're going to be collectively bargaining with student athletes and whether there's going to be revenue sharing. And they're already starting to run those models because the writing's on the wall.
Kristi, on the House case, there's been some urging from various people for that case to be settled. Is there a number that the NCAA could afford that doesn't completely burn the house down, literally?
The NCAA has got reserves. COVID obviously impacted that negatively. If we were talking about this pre-COVID, they would have had more of a war chest than they have right now. I think that they should be pursuing some sort of settlement, but I'm not sure that they are because it doesn't seem to me like they are being realistic about their odds in some of these cases. They are just going to, go down fighting every single one of these and hoping that they get a sympathetic judge along the way. So I haven't really heard anything about any sort of significant settlement discussions happening in that case.
Kristi, before you go, I'm really curious. You mentioned the work you do, visiting and working with different entities. Can you explain how that works and how and what you, not breaking confidentiality here, but what kind of advice do you give respective schools?
Yeah, I go and I work with a company called College Sports Solutions that's run by a former AD, and we do strategic planning and economic impact reports and all sorts of different things over the decade or so that I've been doing it. But right now, what people want to know is how do we prepare for the future? And that's a lot of different things right now. It's are we going to bring our collectives for NIL in-house, and what is that going to look like? And can we bring it all in-house, or do we want some of it to stay outside because of potential Title IX issues and some other legal liability that might come up? And then they're talking a lot about revenue sharing, and it's been interesting to see the shift in that because I would have said 2 years ago, athletic directors didn't want to talk about revenue sharing, but now they know that that's likely coming or that might be a good compromise along the way as they're negotiating with student athletes down the road. So many of them are preparing for what their athletic department would look like if they had to engage in revenue sharing or running that budget forecasting for if they're employees and you're paying minimum wage and you've got to fund benefits. And is it every team? Is it every athlete? Is it only scholarship athletes? There's still a lot of questions that haven't been answered. But I think athletic departments, at least the ones I've been in at the Power 5 level, but even ones I've talked to that aren't Power 5, even D2 and D3, are trying to figure out how all these different decisions could impact their department. And they do seem like they're being proactive in having plans ready to put into place, as soon as one of these dominoes falls. So for the first time, I think, since I've been covering this for the last 12, 13 years, it feels like people are being proactive and aren't just waiting and being reactive. So we might see, I'm optimistic, we might see some positive things here.
Fantastic conversation with Kristi Dosh. We really appreciate you joining us. We'll stay in touch as we head to the break right now. There's a lot more to unpack here on a Wednesday afternoon. We'll get to your phone calls right after this.